I think that the whole session should run in a form of dialogue. So if you have something to say, please raise your hand and you'll be given possibility to speak. We will have some short presentation in the beginning of the session just to start our discussion. Because talks and ideas about possibility to discuss surveillance and national security and governments and its laws is really difficult. But also we should always mention that people have rights. There are fundamental human rights, maybe some of these rights modified with appearance of internet. So I hope we'll have a good discussion. My name is Alexander Isavnin. I come from Russian Federation, a country where government and law enforcers do not like to have dialogue with civil society and with its citizens. They're just issuing orders. So that's another reason why I'm really interested to participate in this dialogue and bring some interesting outcome back to my home. So let's start. First of all, I should note that internet was created by a scientific community more than 30 years ago, and creation was funded by state, but there was no special requirements set up by government. So scientists did a very funny thing which they liked and which developed, and now every of us is using it, and we like it. No special laws was created at that times. There was no special international treaties like around telegraph and telephony and ITU was enforced at that moment. So do we still need a creation of new regulations and government interactions for this? That may be one of questions for our discussions. I've created some short, and I don't think that it's comprehensive list of pros and cons of government participation. Again, I'm from Russian Federation. I could speak about negative impact of Russian regulations and Russian law enforcement to Russian internet for about 5 hours without limits. But now, well, I would not do this. So the possible objections against great governmental interference to internet might be on this slide. Okay, first of all, internet became successful without any governmental interference. We should remember this. Internet as information technology brings a lot of new options for mass surveillance for states. So we could also discuss a bit later. Governmental internet regulations may require excessive identification and data retention for you. Russia is also a great example for that. You can go, unlike here where you can connect to Wi-Fi instantly, in Russia you need to identify you somehow. Some countries implementing illegal and illicit content blocking. I think a lot of people have agreement on which content is illegal, but for different countries, different content is illicit. And even some services may be welcome. Internet allows law enforcers to imitate their activities. If in pre-internet era they have to chase a criminal to go outside to do something, now some of them prefer to sit at their offices doing whois queries, looking in Google Street Views, and then trying to find somebody who they decide is a criminal. Or another point, for example, it's very risky in Russia to publish photos from the Second World War, even with Russian soldiers, because if some Nazi symbols went on these photos, it could be interpreted as Nazi propaganda. Well, definitely the whole picture is not. If operators and businesses must apply content blocking or mass surveillance, it could lead to corruption for the interests of some companies who are producing such equipment. Russia is also a good example. Some countries may implement internet-related, internet business-related protectionism for their businesses. I think another issue, which is non-governmental regulations. Nearly all regulations had exceptions for law enforcement and governmental agencies. Such exceptions, for example, exist for Russian personal data regulations. I think such exceptions is newly discussed GDPR also exists, but we'll discuss it later. We have presentation on this topic. Government regulations and laws from different countries are not compatible to each other. I just mentioned the Russian personal data protection laws. It's completely incompatible with GDPR. So in some cases, the Russian company may have issues because they can't implement GDPR and Russian regulations both at one time. That was some example of cons. We have pros. Only states have possibility to enforce something. And for internet, it's enforcement of communication secrecy. It's very important. There was some scandals related, for example, Facebook and Cambridge Analytica. It's kind of parts, not just personal data, but also communication secrecy. Only states could watch for consumer rights protection. And consumer rights protection in the internet is maybe one of the positive regulations which exists in Russia and works completely. The states and governments may protect business development. Usually only states cares for national and international security. But again, maybe there are a lot of businesses who cares for international security on the internet, but maybe in some cases states should take. We all know that states and ITU, like international organizations, cares for sustainable development. Businesses might not be interested, but states could regulate something related to this. Another argument is the internet was developed more than 30 years ago, and the basic technologies behind the internet are still that technologies. Maybe government should make interference and start implementing something new. In the name of our session, there are internet rights. We all remember basic human rights, but did internet brought some new forms of rights, or new forms of realization of basic rights? So, me as a network engineer in a closest past think that's one of this fundamental right is possibility for have global IP connectivity. So whenever I exist, whenever I reside, I could connect to somebody else wherever he locates himself. Internet bring new options for expression your opinion. You not just go to Hyde Park and speak. Your opinion could be heard not just in center of London, but everywhere. Another closed right is possibility to stay anonymous. If you're a opposition activist, a human rights protester in some totalitarian country, you may have to stay anonymous to avoid any punishments. Another interesting right to be forgotten. Previously, we can't forget Mr. Herostratus, so I think some people don't want such fame now. So I would like to invite some speakers to give positive or negative examples of government regulations. So now let's start with you. NATO representative of Georgia, please.
Good afternoon, ladies and gentlemen. I represent e-government agency of Georgia, and I will make my speech in the angle of good stuff and how government is really protecting privacy and personal data in the same way of providing public goods and services. To start with, I will start with the definition of what, in my opinion, are the internet rights. This is all those conventional human rights in the digital era in line with access to internet and the use of internet. And by the way, Georgia is one of the countries which defined access to internet as a human right in its constitution. But how it will be in practice implemented, this is the second question. Also, internet rights by many scholars are defined as the fourth generation of human rights, and government needs to take it into duly account while providing public goods and public services. We don't really argue nowadays that it is also our human right and obligation, positive obligation of the state to provide safety and security, to provide constitutional order, rule of law, and in this process, of course, government needs monitoring, surveillance, controlling, and law enforcement functions. But the borders and boundaries here, this is what matters. Because if we, without the oversight mechanisms and without the proper due process, there is a big temptation for the ultra-virus activities from the government, abuse of its powers, and mass surveillance. If we don't control the legitimate powers of the government, we may end up with the digital 1984, where really people behave with the control and behave and think with the control of the government, and where our minds are really in the digital prison. So where is the boundary and how we can ensure, on the one hand, protection of internet rights and the protection of safety and constitutional order on the other hand? I will quote from the Constitutional Court's decision of Georgia, where it states that effective protection of any right in this process it is decisive to define the content and limits of the rights. Otherwise, there is a risk and temptation of both disproportionate interference into the right and abuse of the right. The state should reasonably balance private and public interests while protecting and ensuring rights. This is the only way to achieve exercising of rights as well as specific public purposes. From this quotation, I just identified the core principles. The first, there is a need of defining the content and the limits of rights and purposes on the states at stake. It is important to have bylaw enacting boundaries, which will clearly define where government powers start and where it ends. There is a clear need for the balance of the public and private interests. There is a really important to have a solid check and balance and oversight mechanisms in place. And in this process, we need check and balances not only within the state agencies and government entities, but from the private sector. We need publicity, transparency, and accountability of the government activities. And of course, in each and every activity of the government, principles of proportionality, legitimacy, and necessity should be met. Just as this is more theory, but how we do that in practice. I will take the examples from the cybersecurity strategy and information security law of Georgia, where it states that very explicitly that, of course, ensuring cybersecurity is the top priority for Georgian government, and it is our national value and national security interest. But it should be done without prejudice to other human rights, without freedom of expression violation, without freedom of access to information rules. So this should be without prejudice to all other fundamental human rights. Also, information security law of Georgia states that information security should be achieved only based on the risk assessment. And case by case, the government entity should decide where its powers goes and where it stops. And in all of these processes, ensuring internet rights should be adhered. And oversight mechanism here is court and legitimate powers stay there. Also, the other example, I said that I come from the e-government agency, and today I have to say that this is the time where IT personnel and lawyers sit together every day in defining new e-services. And we, together with software developers, business analytics, and lawyers, define how we are processing personal data or business data of our consumers. How long we can retain this data, what is the proportional data that we need to have in order to provide public goods and public services. And here again, this is how we interpret the law, and the second is then the authority of the Personal Data Protection Inspectorate and the court system who will check if we are doing this in line. And e-government agencies, not only the one, all e-government structures in Georgia work like this. So this is from my side. Thank you.
Okay, thank you very much. It's really interesting. For sure, but let's be short. Yes, you may ask question. But introduce yourself, please.
Grigory Sagian, Internet Society Armenia. You told about cybersecurity and informational security. So could you please describe what is your understanding of difference of these two terms?
Thank you for the question. In Georgian legal system, we have a law which has two distinctive parts, but they are very much interrelated. The law is called Information Security Act of Georgia, which has two parts: information security policy and cybersecurity part. So cybersecurity is part of the information security. So information security is much broader sense, much broader definition, and cybersecurity becomes a part of that. And how we do that? On the one hand, we ensure that any critical information system subject or critical infrastructure has information security policies and standards in place. In any daily life, we are in the process of defining what is information asset, what risk-based approach we are conducting in terms of information management. And on the other hand, we are protecting technically security of these systems, and this is the stuff or the job of cybersecurity personnel. So the broad definition is information security, and cyber is part of that.
Okay.
You mean, where is the part which is related to content?
Grigory, another short question. Is it possible to read this legislation in English? Is it translated?
In English and in Russian as well. But yeah, well, content is related to both, to cybersecurity as well as information security, because asset management is the job of information security managers, but protection technically of this content is the cybersecurity job, in short. But I will be happy to speak about the strategy and law in detail.
Okay, thank you very much. And I give hand to another speaker. Please, Martina.
I want to bring the trade perspective on the table because I think here it's not discussed enough in this kind of forum. I wanted to ask first, who knows what the WTO is, World Trade Organization, if you are familiar with the WTO? Anyone? Oh, yeah, 2, 3.5. But yeah, it's like you're familiar with the process of the WTO more generally, or you know what it is? But, okay. You know what the GATS is? Great. You know what the GATS exceptions are? More or less. Okay, I will not use the slides actually because they are quite technical, and I thought it would be a bit boring to present them. So I just wanted to give you really a trade perspective on how to approach restrictions on trade, and in particular data flows restriction in a trade environment, in a trade setting such as the WTO. Because, and the reason why I want to talk about this is that a lot of measures that we see today that apply on data flows might be subject to removal and be considered invalid under the WTO, and therefore a country might be requested to remove this measure if it is violating WTO. So I think it's actually one of the most important tools, probably the only tool we have internationally to require another country to remove a law that, for example, has impacts on freedom of expression if this law does not comply with WTO. So for those who don't know what WTO is the World Trade Organization, and is an organization that regulates trade and trade relationship between countries, and there is over like 160 members. So it's basically the entire world, and those countries who trade are in WTO today. And what we have in WTO is a commitment by member states of the WTO to liberalize trade between countries in goods and also in services, and also other kind of agreements that regulate IP, etc. So what countries do when committing to liberalize trade in services is to decide which services, there's a schedule of commitment, which services they agree to let flow between countries. So for example, many countries have agreed have committed to liberalize computer services and between countries. So if a country is imposing a measure, a regulation, which is actually making it harder or more expensive to provide the service cross-border, this measure is subject to a procedure that can consider this measure invalid and can request the country to eliminate and to remove this measure or to adjust it so that it doesn't create restrictions to trade. And if you have the example of, for example, of the Russian regulation on privacy, which requires data to be processed locally, for all private data to be processed locally, this measure can be seen as a cost for business as well, because any company that wants to provide a service to Russian consumers has to store data in Russia, and therefore this increases cost of providing services cross-border. So it might be the case that this measure could be subject to a WTO dispute. For example, the US could bring Russia to the WTO and say, this measure you are imposing is actually creating costs for my companies, and therefore you should remove it. Now, the reason why you should remove it is not that it's, for example, having implications on freedom of expression, etc., but actually is for trade. But still, that's one important and tool that we have with the objective to facilitate trade. And what happens when a country brings another country to a dispute settlement? That's how the procedure is called. There's a panel that is created in which it is discussed whether this measure is actually representing a restriction to trade or not. And there are two types of exceptions the country have to justify imposing a restriction when this restriction restricts trade, is a restriction on trade. So you have general exceptions and security exceptions. So general exceptions have to do with privacy and public order. So what Russia could say is that this measure for me is necessary to protect privacy of my citizens, and therefore it falls under one of the exceptions of the WTO, and I should keep it because it's protecting privacy of my citizens. And what is done there is then the panel will need to check whether this measure is actually improving privacy and whether it is the least trade restrictive option to protect the privacy of the citizens. And personally, what I will argue is that if there was a case like this, it would be very hard for Russia to prove that this measure is the least trade restrictive way of protecting the privacy of the citizens. And in the same way, when you look at the cybersecurity law of China, for example, which is imposed under the national security objective, it would be very hard for China in a WTO setting to prove that keeping data within China makes the country more secure from a national security perspective. So if there was a case like this, and there have been no cases so far on the digital economy, on data flows, there have been a couple of cases on digital economy, but it's really, we are still at the beginning of seeing cases around digital. But we have seen a few days ago the US representative that had just said that the GDPR is a restriction to trade. So we might see tomorrow the US bringing the EU in a WTO dispute settlement and say that GDPR is actually restricting trade. So if that happens, we will need to see how to approach all this case. It will be an interesting tool to examine whether a measure is actually achieving the objective that the country is saying it is achieving, like national security or privacy, or if this measure is actually implemented for other objectives, which are, for example, surveillance or for simply benefiting local companies at the expense of foreign companies. So yeah, that's everything I want to say.
Okay, thank you very much. It's very interesting approach about harmonization of different laws. So may I ask to switch presentation to next one? Can you switch presentation? Well, we will have a next presentation with example. No, it's previous. Martina Lakis spoke without slides. None.
Okay. Yeah, thank you. I'm going to start. In the meantime, we find my slides. So I really didn't want to talk about this, but as it has been brought up, I have to say in advance that my organization, the Council of Europe, has a completely different approach to the question raised by my colleague Martina. And there is an ongoing negotiation, that's for sure, which is very tense with the WTO and the GATT. But we, as the Council of Europe, we have a more human rights approach to this whole question. And in my short presentation, I hope to be short because it's very difficult to speak in 5 minutes on what Council of Europe is doing in terms of surveillance and protection of human rights and rule of law, but I try. So to begin with, I'm gonna maybe introduce you to some of the Council of Europe instrument, because the whole organization was created after the Second World War and is promoting human rights, democracy, and rule of law. So we have instruments, international instruments on this field, and which is very relevant to our topic today of the surveillance. We have, I will cite two of them. One is the Convention on Prevention of Terrorism, for instance, and the other one is cybercrime, which foresees the access to data by law enforcement in certain conditions. But I also want to highlight that, for instance, the Committee on Terrorism has also worked very hard on recommendation on use, and it's a secondary regulation, a soft law measure, but it's very much taken into account by our member states. On the use of special investigative techniques. And what is very good in our organization is that if a committee is working on a specific issue or consulting other committees, so on this, the use of special investigative techniques, which basically says that how a wiretapping should be done, what are the conditions, how a direct access to content should be carried out by police. We, as the Data Protection Committee, has been invited and we participated in all this. This is the case also for the Cybercrime Convention, as you may have heard about it. Currently there is a quite an important work on the second additional protocol, which will foresee a new regime on the access to data cross-border by law enforcement authorities on cybercrime issues. So these are the examples from rule of law branch or part of the House. Where it comes to human rights, the Committee of Ministers in 2016 have adopted a recommendation which says the convention, the European Convention on Human Rights, which I'm sure that you are very much familiar with, applies both online and offline. This is the first sentence. So although we don't have a specific instrument, international treaty or convention related to the internet and to the rights of internet, the recommendation says the whole convention applies to this. In this spirit, the Data Protection Committee lately adopted a guide on the use of data by police, and if I have a time, I'm gonna speak a little bit about all this. But to be on the safe side, I'm always referring, okay, to the court. I have 30 seconds. So, okay, I'm gonna wrap up, sorry? Okay, yes, okay. Now I'm gonna speed this up a little bit. So the court, which is a unique court, an international court which can make binding decision on member states, has established the legal requirements for surveillance, and it started as of its first case, the matter in 78, and it was a class and others. You know, and already in the class case, it has established the three very important criteria which a law enforcement action or operation has to comply with, is that it has to be in accordance with the law, serves a legitimate purpose, and it has to be necessary in a democratic society. Of course, there are several parts of how we should interpret all those, and in further cases, the court itself is specified what does those mean. You can see on the slide what are the requirements for the criteria in accordance with the law. In Malone versus the United Kingdom, we have several specifications how the law should look like in order to be to respond to the criteria of legitimate or lawful access to data. In Huvig and Kruslin cases, you're gonna see, and more importantly in Weber and Saravia, you will have minimum safeguards to the law. After came this, it clarified what does the court mean on necessary in democratic society, and you see on the slides, it has to respond to a pressing social need, it has to be proportional to the legitimate purpose, and there is always a margin of appreciation which has to be interpreted pretty much in a narrow sense. More recent cases, the Zakharov, the Sabo cases, we've seen some more specification on the conditions. So there is this criteria and requirements of reasonable suspicion, strict necessity, and judicial authorization. So you're gonna have all this on the slide. What does those means really? Would be of course glad to respond further question on this, and maybe some new cases. One is being the Ivashenko versus Russia, which the court found there is no violation of Article 8, and in another case, in the Bendik versus Slovenia, it found there has been a violation of the data subject. Of course, there are very interesting but very difficult cases. You can have some references to all those case law, and I'm gonna end here, and I would be glad to respond to questions or to speak you more about the guide on police which the Data Protection Committee adopted recently.
Okay, thank you very much. We finished with examples from an org team, so we have to start discussion with audience. I think we came from many different countries, we could have different examples, we came from different industries. So if you have some questions or thoughts, or maybe some notes on how things are going in your country? Yeah? But don't forget to introduce yourself.
I'm Lauren. I do some research, particularly on IT and cybersecurity with the University of Oxford. And I think I'll just bring in some observations. So I think Inata said something really important, is that government can do a lot without, listening to everybody's communications, for example. It can guarantee things like, access to the internet as a human right, making sure the infrastructure is up to date and functional, and so on and so on. You could also think about the government doing things along the lines of pushing security per design, so you don't just, bolt it on in the end, but actually support the products that do actually work securely, or at least sufficiently securely, when they come out. When it comes to regulation, though, I think the big question is, how do we regulate? How does government regulate? So security, I would say, is a common good. So it's something, if we then start backdooring systems, that is like the perfect entry point for, criminals, abuse actors, and so on and so on. So I've done quite a bit of empirical research on IT security regulation in particular. And what you hear from professionals when you kind of talk to them, when you survey them, they kind of say, look, we need to have influence. We have to kind of say what's happening on the ground. And this has to be addressed when regulation is happening. It has to be applicable to the work we do. It shouldn't be difficult to understand in high level, because we don't have the time and the ability to actually kind of deal with this. So I think this is one aspect where we definitely have to do a lot of work for this to function, if we say, well, there is a role of regulation here. The other thing I think is really, which was also touched on, the question of how much can be done for what. So for example, when we say takedowns, this may be stuff that's used by cyber criminals to do, phishing. That's one. But takedowns are also, someone took down your YouTube video because you played 30 seconds of a certain song, and now it's owned in, not really owned, but taken away from you by, the rights holder. It happens automatically. Humans don't look at it until you complain. The same is with the local processing, can be good, right? In some cases, can mean that there is actually some level of audit going on that goes beyond box ticking on how these data are processed. On the other hand, it can also be bad depending on where you are, because that means the state has got access, or some other kind of regulatory agency. So to finish my comments, I just want to reiterate, the question is, how do we deal with this common good of network security? It is good for all of us. It's important for the economy. It's important for us to communicate. At the same time, though, if regulation works in a problematic way, essentially, we may actually decrease the common good rather than increasing it.
Okay. Any other comment, Peter, again?
Yeah, thank you. Sorry, Adam. But it was a question that popped to my mind, or rather a comment regarding your comments even yesterday. So I think the internet is like an infrastructure, and it's in technical or legal terms, it's not very different to the road infrastructure, to air traffic infrastructure, to other infrastructure we have and we used to have. I mean, states, citizens, society, international community is dealing with it. Of course, there is much more need for an enhanced cooperation on this in various levels, but I'd see it as an infrastructure, which is a critical infrastructure.
Try to avoid words critical infrastructure, because if you say something like critical, governments pay much more attention. The main internet principle for me as for engineer, and I want to share with you because you are mostly lawyers, I think. Do not create critical infrastructure. So internet was intended to survive during nuclear bombings. So no part of it should be critical for running business. Good examples, the latest DDoS attacks with terabits of traffic, we all heard, but I really doubt that we have more than 2 persons in the room who felt this great, who was disturbed and its business was disturbed by this attack. It happens somewhere else, and we use it other services. But to facilitate this discussion, we see really different points of view from different actors. And I feel that there are a lot of gaps in this discussion. We did not have much more, we did not have many examples of possible regulations and possible negative impacts. So please participate, because these questions are asked by government agencies, asked by academia, asked by civil society, and we're still not in touch with each other. I really like approach from World Trade Organization, possible that there are mechanisms to harmonize regulatory things. So maybe just somebody from audience. Okay, may I call a person whom I invited to this workshop and who may have completely different point of view. We have former representative of law enforcers who are now working for internet governance organizations. Dick, please, could you tell us something, well, on our subject, on the importance of surveillance and enforcement laws as a representative of LIAS?
Hi, Richard Leaning from RIPE NCC, and as Alexander said, I am an ex-law enforcement officer, and there's others in this room as well, so I'm looking at Virgil over there. It's an interesting discussion, and as normal in this EuroDiG environment, it's very high level, and we're sort of moving all over the place on it. And I haven't been a law enforcement officer for about 4 years now, so I'm slightly out of date, and it's not my day job, so I'm only speaking as an individual and not representing anyone at all. It's an interesting topic because for me, as a law enforcement officer, I had a mandate to make sure the public I served was safe. And that's in the real world and online as well. And I think the public want that. As Article 8 says, you know, everyone has the right to life, privacy, etc., etc., etc. And it's really challenging for law enforcement to investigate crimes on the internet because of the way the internet is. You know, the anonymity of it, and it has no boundaries, etc., etc., etc. But the thing is that law enforcement don't make laws. That's the government's. If people are unhappy with the legislation, then they need to lobby the governments, not law enforcement. And hear about mass surveillance and on this type of stuff, I find that quite weird because there's only one organisation, agency, that does mass surveillance of the internet, and we all use it, and that's Facebook and Google and things like that. They're the ones that are doing the mass surveillance. They have far more details, more data on everyone in this room than any law enforcement agency will have. But we all use it. We're quite happy to use it. You know, all the blogs in this, you know, in the last 2 days, everyone's posting Facebook pictures and thinking nothing of it whatsoever. They're the ones that, you know, when we talk about mass surveillance, they're the ones that you should be focusing on, not governments and law enforcement. So, I mean, it's a challenging job, and law enforcement, I'm not saying law enforcement have got it right every single time they've done it, because it's new to them, and maybe the balance was slightly in the wrong way, but it's a learning experience for everyone. And I know law enforcement want to work with everyone and be involved in conversations. That's why law enforcement used to come to these and the IGFs, and that's why we've got government representatives here as well, because it's new and we don't know what's going to happen in the future. You know?
Okay, thank you very much. May I instantly reply? the situation in our region is completely different in different countries. You mentioned you are not implying laws, but we have a conference about months ago where we invited a parliament member. And he said, if FSB, the Russian Special Security Agency, came us with new legislation improving mass surveillance and giving them a right, we could not refuse. So development of Russian legislation on surveillance and powers of law enforcement, they're getting more and more and more power. Another maybe point why we have this discussion here, because for the mass surveillance companies like Google, Facebook, and others, the reputation mechanisms are working. Unlike for governments, it's difficult to change the governmental structure, but with Cambridge Analytica case with Facebook, a lot of companies left Facebook, like Elon Musk, with those companies left Facebook, and it's kind of reputational. It's very difficult to change something, much more difficult to change something for governments in this case. So, okay, Martina, and then Peter.
I want to just say two things. One is it's very different. Of course, Facebook, the issue that Facebook has a lot of data is a problem. Of course, it's like obvious, but it's very different the quality of having a private company looking at your data and using it for marketing purposes, or a law enforcement agency and a government having access to data that, of course, can have implications on the freedom of the individual in the country. So I think the fact that we have a big problem with Facebook does not mean that we should not focus also on the fact that enforcement agencies have access to all this data. And the second point that I wanted to raise, is a question to everybody. The reason why we are fragmenting the internet today is that we have our own, each country has their own value, and they want to have their values reflected on something that is actually shared by all countries. How do we solve this impossible dilemma? Do you have some suggestions? It's something that always, there are some examples of cooperation, but really I would like to hear if you have some suggestions or examples that how now to resolve this difficult question.
This time I agree completely with Martina. So yeah, this is for in my assessment, this is the difference that law enforcement is part of the executory, so the execution branch of the state, and it's under political / administrative direction. So they are following instructions, they are following political agenda, and this is something which is very interesting because you mentioned Facebook. Of course, Facebook, until it did what it did, of course, data protection community already was very critical and asked since the beginning more transparency from society like Facebook, which has built their business model on the exploitation of personal or the reselling of the personal data of their customers, but by the time Facebook got into some political activities which would affect our democracy, which would affect the voting system, which would affect our values, Mark Zuckerberg has to immediately go before Senate. He has to come to European Parliament, and he has to make overnight some very critical measures how they will process personal data. Of course, as a data protection expert, I will not say that Facebook has become, I don't know what it has become, it's unclear, but there is a threshold, and this is the political / sovereignty issue where you are representing the state sovereignty. That's a different story, and that is for a very good reason.
Lauren?
Thank you very much. I just wanted to comment on a few things. So you mentioned the infrastructure idea. So this is actually something I went into. So you mentioned air traffic. The interesting thing there is everything is tried to be standardized, right? Every time there is an incident, all the manuals get updated, everyone gets checked. It's really top down. And planes are essentially designed to be the same, particularly from the perspective of the air traffic control. I think with IT infrastructures, it's a bit more like Lego. We have bits that are the same and that we all use, but then we combine them in different ways. So Alexander's networks and systems are different from the ones I manage. And I think this is what makes things more complicated. And I think that also ties into what Alexander said about, no element should be necessary for the internet to work, but I believe we are more and more going into the direction where there are a few so central key actors that if they went down, we would actually have an insane interruption of service going. And then with the police, yes, public safety is obviously very important. The police can take action, usually private companies cannot, but that is what is also changing. We now have these policing by private actors, I mentioned with YouTube, but it's also elsewhere, where essentially we're moving from, this is clearly phishing, obviously let's take it down, to, a rights holder claims this may be theirs, and that's enough to actually kill something off. And I think this is where the problem starts, not necessarily that we take down phishing sites. Thank you.
If I also may comment, to start with, what is the purpose of lawmaking? Just regulating or enabling? And this is the key difference there, that law should be constructed in a way to enable humans to exercise their internet rights, and not just having boundaries where my authority starts and where it's finished. And it is the key in defining internet human rights. The important was that last year Georgia conducted e-readiness survey, and 90% of the respondents say that privacy for them matters. So it's not the issue that I'm not doing anything wrong and I don't care whether I'm surveyed or I'm under surveillance or not, but 90% of Georgian population cares about privacy. And this is one of the key factors whether what is the take-up of e-services in Georgia. Because am I, as a Georgian citizen, trust in my government and whether I use e-government services or not. That's why when we are doing or constructing any new e-service, and we are collecting a lot of data, and you're absolutely true then saying that not just only law enforcement agencies, but government agencies providing goods and services, we collect and process a lot of personal data. But the issue here is who controls how we are processing. Whether I can just request information to civil registry during the last 6 months, how and when processed my personal data, and get this information. And then if I'm able to then sue the agency who has done improper job to the court or to the Personal Data Inspectorate. This is what matters. Empowering citizens how to use their internet rights and how to control legitimate usage of the rights. And in many cases, unlike to the law enforcement agencies, government is under more control. The e-government agencies have more control from citizens about the usage and processing of the personal data than law enforcement. This is the case from Georgia.
Okay, and I want to reply to Lauren about interference by the states. Again, internet was not designed to fulfill state functions, but one of the problems might be when the states comes to the internet and then tries to enforce something, or for example content blocking. Internet completely not designed to block content on the network, in the core of the network. Even really good legislations like anti-terrorist legislation or child abuse legislation could start breaking infrastructure. As we gave as an example, one of the first issues with internet, the Morris worm, it was in 1986. I think not much people was born already from this room was born at that time, so but mostly are much younger. And Morris worm have stopped the internet at all, so they have to deal with it for 2 days. And mass DDoS, even with 1.7 terabits, they have not stopped the internet as whole. Not all people mention it. So internet was developing, and the governments, even with such good intentions like protecting citizens, could infer the greater disturbance. So there were previously one case appears, it's resolved, but government and states are always here. They could be as civilized as Georgia or as police state as Russia. And in Georgia it moves forwards, and in Russia it moves backwards. I want to ask our remote moderator, do we have any questions from online? No.
We do not.
Okay. Don't forget to introduce yourself.
Of course, yeah. My name is Auke Pals. I'm from the Netherlands, and I'm here on my own capacity. I want also to react to the comment you made. I guess the problem that other companies are trying to enforce really strictly is also a problem of regulation, because if every country or every region makes its own strict legislation, the companies cannot adapt to every single legislation, so they will follow the most strict one and take down that content. So I think on some way regulation or legislation is a problem in that way. On the other side, governments do have a privileged position because they make or some way the legislation, and they can decide themselves if they want to take down some content or just enforce on some way. So I think that's the difference between the companies and governments in that way. Thank you.
Yeah. Martina, I think was okay.
Yeah, just quickly. I think you're very right, Alexander, with the infrastructure does allow access. The problem is, I think most people nowadays do not use the infrastructure the way you're used to, but they use Facebook and YouTube and these channels, and as soon as it's not available there, it's not available to them, right? And that, I think that is the problem, that these key players have emerged, where then this type of enforcement, be it by the state or in a lot of cases actually private, is possible. And yes, I agree. Like there is a problem with over-regulating, right? And a lot of the stuff that is done, looking at my empirical data, is actually seen by practitioners as negative and problematic for their work in actually increasing security. And the only thing that they like and that seems to work is participative, like regulation, where people actually know what they're doing on the ground, are involved in the process.
Yeah, okay. Then Martina?
I have another question, again, like since the first one has not been answered by anyone, about the future of the internet. You were talking about the fact that also content blocking or regulation creates an impact on the internet infrastructure. So do you see the need to change the way in which the internet infrastructure is designed in order to respond to the needs of countries to impose their regulation on their within their countries? And if so, if the internet is to evolve, how can it evolve in a way that remains one?
Well, really, it's really interesting question. So how internet need to be changed to how it must change itself to comply to government requests. Okay, the question. Well, my answer, my personal answer, is internet need not to be changed, not because of governments, but because its idea was to be global and not regulated. So internet was not regulated from beginning. So that's why its growth was so successful. That was because we had a guy this morning from ITU, and as far as I remember, ITU tried to create something like this, like packet switch network. They even invited Windsurf and Leo Pouzin from France And they ran away because they could not fit in this bureaucracy, because all these telephony protocols had to comply to that interest and those interests, and we had telephony monopolies before internet. Nearly every state had its own telephony monopoly, which had interconnections to telephony interconnections to other states, and because of those standards, why internet have won? Because you had not to pay for implementation of standards, so you do not pay royalty if you do TCP/IP in your equipment, unlike ITU things and proprietary standards. And internet was built on the things which worked. So even OC model protocols, not OC model protocols, IC is a set of protocols which comply exactly to IC ITU's model. They was not successful as working. Even you buy one equipment from IBM and another from another producer, these two telecommunication devices could not work together. You had chance that they will not work together. But for TCP/IP, which brought the internet to success, it worked. It worked at academia. That's why it was selected. And then I really thought that if we start complying interests of states, the internet would not be internet. It would be, again, public telephone network. And, well, on my opinion, not as moderator, but as person, our task is to bring this understanding to our states. In some cases, some states understand it. Some states refuses it. It's dialogue. Georgi?
Grigoris again. I think necessary to underline the role of such huge companies like Google and Facebook, because they are more powerful in some cases than governments, and they have a policy for self-regulation. As an example of self-regulation, you can see that in each country, these companies are establishing their caching servers, and it gives them right to have different rules in different countries, because they are using local proxy server in which they can adjust their policy with local regulation. It's necessary to remember about that not only American laws are acting in particularly this country, but these companies themselves, they are regulating themselves without government influence in order to enlarge their business.
Hello, I am Irakli Kwenetadze. So I think what is role of government in this situation? Government have to teach citizens how to protect citizens, businesses, and etc., how to protect themselves, and also we have to make big awareness campaign what risks exist in internet. We have to not regulate internet, because absolutely internet's concept, that idea is to be free. So exactly with this approach, citizens will be identifying risks and problems what is exists in the internet, and we will be identify resources and solutions, how to protect their companies, their businesses, etc. Law enforcement, of course, have to be ready for any case to just support citizens and protect citizens and businesses' security. And exactly this approach was taken by Georgian legislation, where just government is proposing companies or not, and so it's not mandatory for everyone. It's mandatory only for critical information system subjects. And we say to critical information system subjects, you have to implement information security policy, which means you have to know what information you are on, what is risk related to them, and after this to adopt control mechanisms to protect your infrastructure. And I think this is exactly the way to just save internet and also keep internet as much as possible as free and open for every citizen. Thank you.
also, yes, government should not regulate internet, but provide the enabling framework where everybody, consumers, businesses, citizens can freely use its internet rights. But at the same time, we came to the point that even last year we've seen so much interference of governments and governments abusing internet in the democratic election processes and so much, because it became the tool in the hands of governments to interfere in the big international politics and foreign affairs as such. That's why it's not just governments, but self-regulation from the private sector, as well as big international organizations, have a role in better defining the roles and the obligations of each actors, state as well as non-state actors. And if we want to have the open and unrestricted and safe internet, there is a really big room for multi-stakeholder dialogue in this case, because these are not just states, but non-state actors should have a big role in defining what is the future of the internet.
Okay, Peter.
Thank you. I just wanted to raise one issue that we are turning around, and I heard a lot of time the government and what government should do or not do. I would suggest maybe to broaden this perspective and divide it a little bit, because the government, of course, has some roles and responsibilities into that, and from our perspective, there are a good variety and a comprehensive net of international convention when it comes to Europe on that, and to guide them and even to bind them to do things or not to do things. But when it comes to the protection of individual rights, it's not only the government. The government has the responsibility to develop or to put in place instances and authorities, such as the enforcement authorities, which are not part of the government, such as the DPAs or media authorities. Those can help protect your rights if it's infringed in the internet. And for countries belonging to Council of Europe, you can be sure that it has to be interpreted as it was a violation outside of the internet. So it's the same. And moreover, you have anti-discrimination authorities in several countries, and parliamentarian committees when you can turn to, and so on and so forth. And on the top of all this, you have the ACTHR, which is, I keep repeating, I realize I forgot to show all of you this because I just clicked on my computer. But here are the Zakharov cases, for instance, and the Sabo cases are groundbreaking and are individual cases, and they changed completely the way governments and authorities are pursuing or are going along with surveillance measures. So I think there are possibilities already, whether if it's efficient or whether if it's enough. Of course, we can have discussion on this, but be sure that there's already possibilities. If your rights are infringed on the internet, you have possibilities to challenge it.
Okay, Dick.
Yeah, I was just going to mention the problems that governments have is the internet is global and you can't split it up because it wouldn't be the internet that we have today. So therefore it has no boundaries whatsoever. And therefore that's the challenge for governments, because they have sovereignty and they're trying to make regulation in their little square on something that they can't possibly do. So that's an interesting challenge, and it's a challenge that's going to be there all the time. And I've heard discussions in my community about, where do we start our own internet? Well, you can start your own internet, but the internet doesn't work that way. Who's going to come to your own internet? You'll just be left alone with no one coming to you. So it's a challenge to find global norms that will make the internet safe. And when we talk about the other examples of global norms, that's top down, and the internet isn't that way. So unless we want a top down internet, that's another discussion. If we want to carry it on the way it is, we're going to have to think of something else to do. The problem I see is trust, and I think we're on the verge now of the internet maybe losing some trust from its users, and if we lose trust into internet, then we are in serious, serious trouble. Because I know you don't like the word critical infrastructure, but there are critical parts of the internet that is there, and the governments have to pay attention to, because how our lives are run on the internet. I mean, on Friday last week, I was flying back from a country, and I was trying to use my visa to get my bloody cappuccino, and I couldn't use it because the visas had gone down.
But this is not internet, this is informational systems.
No, but it's on, I understand that, but there's things like that we use the internet for that facility, that if it went down, that's part of a critical thing that everyone uses, then that is really going to be focusing people's minds, you know, so we just have to be aware that what we're going to do is...
Yeah, you mentioned trust. I forgot to add it to my introductory slides, because one of the role of governments and states is trust anchors. So we had to trust somebody to let them enforce in this case. But in internet, we also have a lot of trust anchors. Well, the well-known thing is that DNS key key is one of one of trust anchors. Another one is security certificates, which we are using for electronic commerce and something like this. So we trust in them. It's one of the But I want to shift a little our discussion. In my country, as I mentioned, the laws becomes tighter and tighter and added more obligations. But as far as I know, in Europe, some data retention laws were cancelled. Wi-Fi identification was cancelled in some countries. So for me, would be interesting to listen, and maybe for others also, how it works with European government when the legislations get rolled back. When the government and state sees that its regulation is too much, how it appears and that it needs to be rolled back. Maybe somebody could answer. Okay, Mark.
And then make a question. In this case, I mean, it's because there was a European Court of Justice ruling that was invalidated the European Directive on data retention. So there was a data retention directive in 2006, and the European Court of Justice considers invalidated this directive because it was considered to be non-proportional to achieve the objective of law enforcement. And what we have seen that so far there's been already, I think this ruling was 2011, I'm not sure. So anyway, the countries had a few years to remove these data retention laws, and they have obliged to remove them. And still there are about half of the member states that have not removed this, and 2 member states that have imposed new data retention laws, the UK and Germany, after the invalidation. So it's not like they were obliged to, and they have not even done it. So it's not like they realized that they had to. They took inspiration.
Peter?
Yes, this is exactly. I don't know if I can be so personal in my response, but this is, I think, a case where it shows that we have a lot to do. Again, so we have a court case, we have clear instructions, and member states are not following. Of course, it's not a Council of Europe case, but it's very relevant also for us. There's a lot to do.
Any other opinions? Please, if you even sit not around this table, but further, share your experience. Okay, so let's wrap up. I think that our current dialogue shown that we need to continue it. There are too much subjects to discuss, too much subjects to, again, to approach. So we have a rapporteur.
Hello, everyone. My name is Aida Mahutovic. I'm here in front of Geneva Internet Platform Digital Watch Observatory. Full summary reports of this session and all of the sessions at the EuroDiG you can find after the event at Dig Watch and on the EuroDiG wiki page. Now, what we have here are basically 4 messages that we try to construct from what we heard, but you're gonna get it in a more broader way during in the summary report. Now, what we're trying to do is to try to reach a rough consensus in the room. You can also show thumbs up or thumbs down, that's also fine. So the first one is, there is a clear need for the balance of the public and private interests.
Anyone objects? No.
Okay, good. Internet should not be regulated in order to keep it free, but provide enabling framework.
Again, any objections?
Good. There is a need for publicity, transparency, and accountability of the government and private companies' activities.
No objections.
Cool. And the fourth one. There are different and important approaches on different levels when it comes to surveillance, laws, and governments versus internet rights, which is why it is crucial to continue the multi-stakeholder dialogue.
No objections.
I think there is one.
Oh, abstention?
Yeah, maybe not internet rights, but human rights.
Okay, so we're
well,
changing the title a little bit. Is that okay?
Yeah.
Everyone agrees? Fantastic, thank you.
We missed to discuss, sorry, it's my failure as moderator, that's what internet, I've stated it in introductory presentation, that's how rights are changed with internet. So does internet add some additional rights? So, but it's a reason to have, to continue this discussion and maybe start from focusing not on surveillance, but on what new internet rights are. Because definition of basic human rights, as far as I remember, is 70 years of previous century. So maybe it's time also to shift definition of basic rights or to internet rights or something like. It's another reason to continue. So we have consensus on
yeah, I would just like to
outcome.
ask if we're keeping internet or human rights? Human rights? Okay, I corrected it, yes. Thank you very much.
Okay. Any other interventions? Maybe somebody want to say wrap-up words? To invite to other location and discussion, please. Don't forget to introduce yourself.
Len Rompainen from Electronic Frontier Finland. So for me, the perspective between human rights and internet rights, it used to be so that we needed to discuss very separately about what kinds of rights should we have in online environments and internet environments. But I think this distinction is actually now vanishing. We are talking about human rights in a digital era. And I think it's easier to talk about human rights instead of bringing up a whole new concept of internet rights.
Well, as far as I remember, in Finland, internet is considered as one of human rights now. That's maybe the discussion should continue. Okay, maybe somebody would like to invite us to discuss these topics at other location, other venues, other conferences. Should we continue discussing this maybe, or not on this ground, on mailing lists somewhere? Okay, Oksana, please. Okay, for the records, Oksana Prihodko from Ukraine invites us to Ukrainian IGF in September. As far as I remember, Ukraine is a visa-free country for Europeans and not expensive as Netherlands, for example. So everyone welcome. Any other wrap-up words? Martina?
So since we're still 5 minutes, and I don't know if someone else has other points of view, but I just wanted to invite everybody. We have not arrived to a consensus or an agreement on the way forward for the internet, whether we can actually make sure that countries regulate it, but still the internet remains one. And I think it's a really important question, not just for the internet, it's for the future of humanity, to think about a way in which we can make sure that the internet evolves in a way that countries feel that they are making their job in ensuring the rights of the citizens and making sure that the citizens are protected, by the same way doing it in a way that the internet is not fragmented into internet. And we see a lot of proposals today from the BRICS, from Russia, in countries, and there is a serious discussion on creating parallel internet just for the sake of ensuring the rights of citizens. So I think it is the most important question to try to answer and discuss in other fora on how we make this happen without fragmenting the internet and risking that this amazing treasure we have of communicating with each other disappears.
Okay, short reply and then another question. It's not BRICS proposal, it's Russian proposal. I've contacted other BRICS countries and well, I did very negative reply from all levels, even from levels of regulators. Okay, let's discuss it. And another question. Actually, the Mr. From ITU got this question, but we did not, so I have to return it. We have representative of EuroDiG here, more than one representatives. So I want to ask Elizabeth or other colleagues, how do you feel this discussion? Because, well, some of us already retired, somebody will go retire in 20 years like me. But what internet belongs to you will belong in closest future. What do you think about this discussion?
Yes, so this is Elisabeth Schaumann. I was co-organizing EuroDiG. We brought together a lot of young people who are very acutely aware of their digital rights and how that affects their livelihood and how they navigate their lives. So, I mean, a problem that might be there, or like there's several issues with young people and human rights. One is a lack of agency, right? There's not a lot of young people in governments, in regulatory bodies. Yet again, there's a lot of young people who are very interested in the topic and very on top of their activism, I'd say. Just to give a quick example of my own experience, in the last German youth IGF, we drafted a message that was very openly criticizing the quite recent law on platform liability in Germany. So the youth environment might give room to more controversy and more activism.
What do you think about this discussion?
I think that we need to, it was quite high level. I mean, in terms of many young people not having a human rights background, it might be necessary to give more education and tone it down maybe to some extent, but yeah.
So you are here, don't hesitate to ask questions and send your colleagues to us. Also, as far as I remember, Oksana invited us to Ukrainian AGF. They also have YAS AGF. So I think you already have one country invitation to discuss it. Okay, we're nearly out of time. If no other interventions, let's close. Okay.
Yeah, I do have one question off topic. If anyone is an expert in responsible disclosure, would you please approach me? Thank you.
Okay, thank you very much. I hope we'll be able to continue this discussion later on the grounds of EuroDiG and other governance forums. Thank you very much.